ሰላም ጤና ይስጥልን። ወደ የኢትዮጵያ ስኩል ኦፍ ላው ቤተሰቦቻችን እንደምን ቆያችሁልን? በክሪሚናል ፕሮሲጀር ክላስ ተመልሰናል። አብራችሁ ቆዩ።
Bail is what we consider bail is it is a human right and it is a conditional release. Bail is a conditional release. Bail is not unconditional. Instead, it is conditional release. Person will be released until such time that the court requires him to appeal. Okay? On every adjourned date, the accused person is required to appeal before a court of law. So, on every proceeding, the accused person who is released on bail is required to appeal before a court of law. It is a human right. It is a human right which is conditional release. And we have considered in circumstances under which a person can exercise his bail right. Bail right, as a human right, it is subject to limitations. In some circumstances, the bail right may be restricted. It is not in all cases that a person can be released on bail. In some exceptional cases, a person may be denied bail. So we have considered the nature of the offense, okay, or causes related to the offense, and character. These are the two conditions under which bail may be either denied or permitted. So I have considered that under Article 63, it is provided that a person who commits an offense which entails rigorous imprisonment of 15 years or more or death sentence cannot be granted bail or cannot be released on bail. Even though these requirements are fulfilled, we also said if the victim in respect of whom the offense was committed has a possibility of death, then bail cannot be granted. And we have also considered the conditions. Even though the first conditions are fulfilled under Article 63, conditions under 67 should also be fulfilled. Like, for example, if the public prosecutor proves to the court that if the accused is released, he can tamper with evidence, or he will not respect the conditions of bail, and if this circumstance exists, then bail may be again denied. And whenever bail is determined, the amount of bail should take into account the determination, should take into account the number of factors, such as, for example, the nature of the offense, the rigorousness of the offense, and the resource of the accused person, and the like. We have considered these issues, and we have also considered the obligations of guarantors. So, in any case, what you should underscore is that bail is a conditional release, and a person will be released on bail upon presentment of guarantee. Without presenting guarantee, a person cannot be released. Bail, in general, requires presentment of guarantee. Needs guarantee. So, whether you are released by police or by a court, and you are required to present guarantee. The accused is required to present a guarantee. That guarantee may be presented either by the accused himself or herself, by presenting his property, or by calling another third party. Third party can present only for the accused person. Okay? So, then what is the obligation of guarantors? The obligation of guarantors is to ensure the appearance of the accused person on the date fixed by the court. That is the obligation of guarantors. Okay? So, if the accused on the date fixed by the court fails to appear, then that obligation is breached, we say. That obligation is breached. But we said that the moment the accused fails to appear on the date fixed by the court doesn't mean that the property, the guarantee will be estorated. It will not be automatically estorated, but there are circumstances under which the court will consider. So anyhow, in general, we say the obligation of guarantors, the law has followed a lenient approach toward this guaranteeship in such a manner that the person who is a guarantee can at any time apply to the court and be released from his obligation. At any moment in time, the guarantor can apply to the court and he can be released on bail. Okay, at any time. It is free. It has policy justifications that we try to consider, such as, for example, to encourage people to be guarantors. Okay? Otherwise, you will not be able to. If a person who is a guarantor cannot be easily discharged from his obligation, then everybody will fear, people will be discouraged, being a guarantor. Nobody will dare to be a guarantor. Okay. So these are such and other policy justifications behind making the obligation of guarantors lenient. Okay. It means, I mean, the guarantors can at any time be free from their obligation. They have the right to apply to the court at any time and be released. And also, if the guarantor suspects that the accused is going to abscond, then they can immediately apply to the court, and whenever the accused is arrested, then they can be released. Okay? So, anyhow, there is a very wide possibility for guarantors to be free from their obligations. And if they do not present justifiable ground to the court, then the property may be extradited. If the accused on the date fixed by the court fails to appeal, and they will be asked by the court to justify why their property shouldn't be extradited. And if they convince the court, then the court may not extradite. But if they fail to convince the court, then that property may be extradited. It will be taken by the government, it means. Okay? So guarantors have such obligation. So having said this, today we will continue from, if you have any question, for the interest of time, since we don't have time, for the interest of time, if you are on your progress of reading, if you have any question, you can ask me after the class, okay, for the interest of time. Today we will start the other portions of police investigation, the other parts of police investigation. So we raised this section. We considered bail because whenever a person is brought to court within 48 hours, the first question under Article 59, the court which the court considers as soon as a person is brought before it is the issue of bail, whether the person should be released on bail or should be remanded. And we raised what is bail and under what circumstances a person can be released on bail. We consider. Then assume a person is arrested by the police. Okay. Then the next step is, as we considered, person has to be brought to the nearby court within 48 hours. Within 48 hours. He has to be brought to the nearby court. And the issue of bail will be raised as we considered. The other activities that the court will do is, the police will do is interrogation. A person who is arrested by a police will be interrogated. So interrogation is a very important activity. Interrogation is a very important activity which helps the police to gather evidence. Okay? So it is questioning by the police. Interrogation is questioning of the arrested person by the police, so that the arrested person may make a statement. So that statement will be recorded by the police, and it will be presented against him, against the accused, against the arrested person on trial. So it is one means of gathering evidence. So whenever a person is arrested and presented for interrogation, so interrogation cannot be carried out like on the way to the police station. Outside. Interrogation will not be carried out outside. It has to be carried out in the office. Okay? In the office. So the person will be brought by the police. Person after being arrested, he will be taken to police station. So in police station, he will be interrogated. He will also be taken to the nearby court within 48 hours, and he will also be interrogated by the police. Okay? So in many cases in practice, it is before taking the person to court within 48 hours that arrested persons are interrogated. Immediately, before taking to the nearby court, they interrogate in practice. They interrogate that person, and after that, they take that person within the nearby court. And the law doesn't provide clarity regarding the chronology of actions. Should interrogation be carried out before and after interrogation? Should it be taken to the nearby court within 48 hours? There is no such chronology. But in practice, interrogation usually is carried out immediately after arrest, taking the person to the police station. Because after arrest, that person should be taken to the police station. It's clear. Okay. Then after they interrogate. Okay. So, what are the techniques of interrogation? Okay, what are the techniques of interrogation? How should interrogation be carried out? How should interrogation be carried out? There are guarantees that there are procedures that are explicitly provided by Article 27 of the Criminal Procedure Code whenever interrogation is made. So, Article 27 provides, the first thing is that the police should inform, during interrogation, the police should inform the accused, the arrested person, that he has the right to remain silent. He has the right to remain silent. Okay? The police should inform that the arrested person has the right to remain silent. He should inform him or her. And the police should also inform the consequence of the statement that the consequence of the statement that the accused, the arrested person makes. The police should inform the consequence of his statement. First, police should inform him or her, the accused, the arrested person, that he has the right to remain silent. He has the right not to answer the questions. So, whenever you are brought to the police station and whenever you are asked, you have the right to remain silent. So, police may ask you, do you know why you are arrested? You may say, okay. But you know, it presupposes that the police should know your right. Otherwise, so it requires good knowledge of the police. Police should know your right. Okay? It requires the police that you have the right to remain silent. Okay? You are not bound to answer the question. I should tell you, as a police, when you are presented before a police station. And in addition to that, I should also inform you, as a police officer, I should also inform you that any statement which you may make will be presented against you in court. I should also tell you this. It will be presented to you against. It will be presented against you as evidence in court. It is after telling this that the statement of the arrested person will be recovered. So, despite this warning, by the way, it is called Miranda right. In the common law jurisdiction, it is called Miranda right. Miranda right in fact. There's a Miranda case under that's developed in the US legal system. Famous case under Miranda right in fact. And the right to be informed about the fact that you have the right to remain silent. The police should also inform the consequence that it may bring you if you wish to speak. It's called Miranda right. Miranda warning. Okay? So, this is the guarantee that is provided for accused persons. And in fact, obviously, there should be also language translator. Is the human right? Okay? There has to be. If the arrested person cannot understand the working language of the police in the area, particularly it is very important in the federal systems like Ethiopia, where the working language differs from among regions. So it is a human right. There has to be language translator. The arrested person should be informed by the language that he understands. Okay? So these are very important guarantees during interrogation. All right? But there are, whenever you read more on this issue, in light of international human rights standards, in light of constitutional provisions, there are also other guarantees which should expand by reading, even though it is not provided in the Criminal Procedure Code. Okay? But for the time being, what is provided in the Criminal Procedure Code, the minimum guarantee in the Criminal Procedure Code is this. That's what Article 27 provides. And, okay, very quickly read Article 27. Interrogation. Any person, someone under Article 25 or arrested under Article 26, 50 or 51 shall, after its identity and arrest have been established, be asked to answer the questions or complaint made against him. So you see, the law has provided a precaution or care that should be taken by the court, by the police. The police should establish the identity of the arrested person. After establishing the identity of the arrested person, then he should interrogate. He will be asked to answer the accusation or complaint made against him. So the question is about the offense. About the offense. Okay, so it has to be about the offense that the arrested person is suspected to have committed. Okay, then the Article 2 provides a guarantee. He shall not be compelled to answer. There should be no compulsion. That is very important that we should grasp. Okay, he shall not be compelled to answer and shall be informed that he has the right not to answer and that any statement he may make may be used in evidence. So he has to be informed about the consequence of his statement if he wishes to make a statement. And any statement which may be made shall be recorded. Any statement which may be made shall be recorded. And Article 4, where the arrested person is unable properly to understand the language in which his answers are to be recorded, he shall be supplied with a competent interpreter who shall certify the correctness of all questions and answers. So there has to be an interpreter if the arrested person cannot understand the working language of the police. So this is a very important guarantee. And I want to emphasize on, in fact, all points are very important. The issue of compulsion. Okay? So there should be compulsion or there shouldn't be no coercion. As your law of evidence provides, any evidence obtained after coercion, any statement obtained out of coercion will not be admissible. Will not be admissible. Okay? If an evidence is provided through coercion. So in many cases, coercion occurs at the moment when a person is at the hands of the police. It is in the hands of the police that coercion occurs in many cases. Whether in the police custody or in prisons, coercion usually occurs at this moment. Before trial, in many cases, coercion occurs at the pre-trial stage. ውሳኔ ከመወሰኑ በፊት ከተወሰነ በኋላ ማን ዞር ብሎ የሚያይ ይችላል። ግን ከትራያል በፊት it is for the purpose of coercing, compelling you to make a statement which can be used as evidence against yourself. So the research indicates that the majority of cases, police gathers evidence through compulsion or through coercion. In the majority of cases, as research indicates. So these rights are very rarely implemented, or these rights are very rarely protected. So there are other guarantees like the right to defense lawyer, for example. The right to defense lawyer is very important, even though it is not provided here. The right to defense lawyer. Okay? So you can, even though it is not provided here, it is provided, you can trace it, it is your constitutional right as an arrested person not to answer a question unless your legal advisor comes or unless your lawyer comes. You can say, for example, during interrogation, whenever you are asked, you can say, I will not answer until my lawyer comes. You can say, this is your right. Okay? This is your right. The right to be represented by a lawyer. It is your constitutional right. It is your constitutional right. So you can say. Okay? So you can, even you have a right to remain silent, as you very well know. And you can also say, I'm not willing to speak until my lawyer comes. If you have the capacity to hire a lawyer. But there is also a possibility for a state-appointed lawyer. But that is debatable. At what stage should this right start? It is debatable. But if you have a capability to hire a lawyer, you can say, unless my lawyer comes, you can say. So if any evidence is obtained through coercion, it is not admissible. But there is a problem. There is a problem. In many cases, interrogation is carried out, carried out in the absence of, defense lawyers. Defense lawyer, in the absence of defense lawyer, in many cases. So there is a very high tendency for coercion to happen. And it is also usually carried out in a closed session, where only the investigating police officer and the arrested person are in the room. So you will face difficulty in proving whether you are coerced or not. So in court, you may say, whenever an evidence is presented against you, which is an incriminatory statement, you have incriminated against yourself due to coercion during police investigation. And in court, you may say, I was coerced. Statement of admission would be presented against this evidence. And you apply to the court saying, this evidence shouldn't be admitted because I was coerced. But how can you prove it? How can you prove it? Okay? In practice, what they do, what arrested persons usually do is they show scars, okay, marks of their body, indicating the fact that they were beaten. I was beaten. They indicate their body. But can it serve as evidence? What if that mark, was due to, something before interrogation? How can you prove it? It is very difficult. That is why the right to defense lawyer is very important. Okay, if interrogation is carried out in the presence of your lawyer or a state-appointed lawyer, it is very important, and it is very unlikely for coercion to happen if it is carried out before your lawyer. This is a very important guarantee. Otherwise, proving is very important. And in the prison proclamation that is adopted very recently, in the prison systems generally, there is medical examination. Before you enter into prison, you have to be physically examined. By the way, coercion also occurs in prisons. Because people whose trial is not yet determined may also be required to remain in prison. It is a prisoner. It's a prison. They are there. Okay. Coercion may also happen in prison. So what international standards provide is that before you enter into prison, you should be physically examined. Okay? You will be physically examined. So that whenever, if you are beaten in the prison, then whenever you appear in court, you apply to the court, you complain to the court that you were beaten. It is due to that coercion that you incriminated against yourself. So you can present as evidence the marks, scars, and the like. So there is higher physical examination so that it may be acceptable. Otherwise, in police custody, this is not usually implemented. In police custody, but international standards provide. From the moment you become under the control of the law enforcement authorities, you have to be physically examined. That is the other guarantee. The other very important guarantee, as I said, is to have a defense lawyer. If a defense lawyer is with you, then during interrogation, then it is very unlikely for coercion to happen. So any evidence other than coercion, other than interrogation, will not be admissible. Okay? It is during interrogations that there will be coercion. So if you prevent it by a lawyer, in the presence, if it is carried out in the presence of a lawyer, it is very important. Anyhow, the point is, proving coercion during police interrogation is very difficult in practice. It is very difficult in practice. So in order to help the accused, okay, in order to help the accused in this way, to prove, to prevent coercion, there is another provision under Article 35, power of court to return settlement and confessions. Please turn your criminal procedure code to Article 35. Article 35, power of court to recur settlement and confessions. Settlements and confessions, mind these two terms. Any court may record any settlement or confession made to it at any time before the opening of a preliminary inquiry or trial. So before a preliminary inquiry or trial, any court has Any court may record any statement or confession. Any statement or confession. What is the importance of using these two terms? Made to it at any time before the opening of preliminary inquiry or trial. So you have another. It means you have another option. You will be taken by the police to the nearby court. Okay? If you wish to make a statement, you will be taken by the police to the nearby court. Because it says any court. So it is a statement or confession. If you want to make a confession, you will be taken by the court, you will be taken by the police. Then you may either make a statement or confession. Okay? Say statement or confession. Oh, you know the meaning of confession, isn't it? It is an incriminatory statement. It is a statement which is against your interest, isn't it? It is a statement which helps the public prosecutor, or it is a statement which helps your adversary to prove his case. Or it is an incriminatory statement. Okay? It is something you make against your case. But statement is this. Statement may necessarily be, statement is broader than confession, isn't it? Statement is broader than confession. It means that statement may be either confession or not. Either confession or not. So, any court may record any statement or confession made to it at any time before the opening of a preliminary inquiry or trial. Before the opening of preliminary inquiry or trial. So you have to be taken to the court, okay? Before the opening of a preliminary inquiry or trial. So before the opening of a preliminary inquiry, if it is after preliminary inquiry, before trial. Then there you may make confession before a court. So during interrogation, you might have preferred not to make statement. You might have preferred to make no statement. But here in court, you may make confession. You may make confession. And it also says statement, which necessarily doesn't mean that it is confession. So during police interrogation, you might have been coerced. As a result, you might have confessed. But whenever you are brought in accordance with Article 35, you can make a statement, which is different from confession. Okay? In Article 2, Article 35, Article 2 says, no court shall record any such statement or confession unless, upon questioning the person making it, it ascertains that such person voluntarily makes such statement or confession. A note to this effect shall be made on the record. So the court should tell you, okay? The court should notify you. What the court do is, the court should notify the consequence of your statement. The court should ascertain voluntariness. Is it out of coercion? So the court, maybe you might have been coerced by the police to make confession before a court. So the police may say, come, we are going to court. And you have to confess in court. Okay? So whenever you are brought before a court, you may confess. So the court should be cautious. The court has to be cautious to check whether such statement is made voluntarily. And a note to this effect shall be made on the record. The court should make such record. A note to this effect. It means the court should record that it has ascertained the voluntariness of the accused or the accused person. And Article 3, such statement or confession shall be recorded in writing and in full by the court and shall thereafter be read over to the person making the statement or confession, who shall sign and date it. The statement shall then be signed by the president of the court. And the article for a copy of the record shall then be sent to the court before which the case is to be inquired into or tried. into the public prosecutor, it says. All right? And in practice, both in academia, in practice, there is a controversy regarding why the law prefer to make statement and confession. Some scholars say the two terms are just used interchangeably. They are just used interchangeably to refer to admission. They argue that both statement and confession refer to admissions. They are just used interchangeably. Okay? The law used the statement and confession interchangeably to refer to similar things. That is an incriminatory statement, which is admission. Okay, which is admission. But there are also other scholars who argue that no, there is a distinction. That statement doesn't necessarily refer to confession. So whenever a person is brought to court in accordance with Article 35, the statement that he makes may not necessarily be confession, according to these authorities. It may be something different from confession. That is why the wording statements and confession, it says. Because the caption, have you seen the caption? Power of court to record statements and confessions. It should have, if the legislator has intended to use them interchangeably, then the term "and" wouldn't have been used, according to some scholars. Okay? So there is controversy regarding this. But whenever you read the statement, it seems to refer that the statement is referred to confession. ሁለት ኮንትሮቨርሻል ነገር አለ። ስቴትመንት ኤንድ ኮንፌሽን ነው የሚለው። ስለዚህ ስቴትመንት እና ኮንፌሽን የተለያዩ ናቸው። ኮንፌሽን ያው ኢንክሪሚኔቶሪ ስቴትመንት ሲባል ግን necessarily ኮንፌሽን ላይሆን ይችላል። necessarily ስለ ወንጀሉ የፈለገውን ነገር ለመናገር ከፈለገ ይወሰድና በ35 መሰረት ፍርድ ቤት ቀርቦ የፈለገውን ነገር ይናገራል። ያ የሚናገረው ነገር necessarily ኮንፌሽን ላይሆን ይችላል። ምክንያቱም ካፕሽኑን የአርቲክል 35 ካፕሽኑን ወይም ታይትሉን ካያችሁት power of court to record statement and confession ነው የሚለው። statement or confession አይደል። ኢንተርቼንጅብሊ ለመጠቀም ያሰባ አይመስልም። ግን ሰብስታንሱን ደግሞ ስታነቡት ኢንተርቼንጅብሊ ለመጠቀም ያሰባ ይመስላል እኮ። ለምን መሰላችሁ? ፕሪኮሽኖች ውስጥ ተነቧቸው። ለምሳሌ ፍርድ ቤቱ ቮለንተሪ መሆኑ መረጋገጥ አለበት ሲል ይሄ የሚናገረው ነገር ሰልፍ ኢንክሪሚናቶሪ ይመስላል። ኢንክሪሚናቶሪ ስቴትመንት መሆኑን ያሳያል። ይሄ የሚናገረው ነገር ኮንፌሽን እንደሆነ ይመስላል። ኮንፌሽን ይመስላል። ምክንያቱም ጥንቃቄ የሚደረገው ብዙ ጊዜ ኮንፌሽን የሚሰጥ ከሆነ ነው ይመስላል። ኦኬ so there is a dichotomy of views regarding this, the interpretation of this provision. But if you ask me how police is doing this in practice, it is very surprising. You know what they do? I was teaching the professionals, prosecutors and police officers and judges, and I asked them how they are implementing it in practice. Police officers, you know, certain police officer, comrade, raised his hand and said, what we do is we warn the accused person, the arrested person, to make the statement that he made during interrogation in court. ስለዚህ ምንድን ነው የሚሉት? ና አሁን የተናገርካትን ተናገር ፍርድ ቤት ይወሰድና አሁን የተናገርካትን ልክ ብዙ ጊዜ አድሚሽን ሲያደርግ ኮንፌሽን ሲኖር ነው ብዙ ጊዜ የሚወስዱት ወደ ፍርድ ቤት። እኔ አንዳንድ ጊዜ ፍርድ ቤት አስሉም በነገራችን በ35 መሰረት ሪከርዲንግ አይሰራም። ኢን ፕራክቲስ ብዙ ጊዜ የሚያደርጉት ምንድነው? ልክ ኮንፌስ እዛ ይቀጠቀጣልም ያምናል ብቻ በሆነ ሚንስ ልክ አድሚስ ኮንፌስ ያደርግ እና በል አሁን እቺ የተናገርካትን ፍርድ ቤት እናቀርባለን ብለው ፍርድ ቤት ይወስዱትና ፍርድ ቤት ይመዘገባል። ኢን ፕራክቲስ ኮርትስ ኦልሶ አር ኖት ቪጂላንት ኢነፍ ቱ ቼክ whether this confession is made voluntarily እንደሚናገርም ብዙ precaution አይወስዱም። But the wisdom behind this provision seems to be that it wanted, the criminal procedure code wanted to prevent corruption. It seems to be that. The intention seems to be that the law wanted to prevent corruption. Because whenever a person is presented before a court, then according to, in accordance with Article 35, he may speak something different from what he spoke during police interrogation. So if you ask my opinion regarding this, in my opinion, how I understand Article 35 is that the statement that whenever a person is brought in accordance with Article 35, he can make either confession or something different from confession. It is not necessarily referring to confession, in my opinion. The law is providing double guarantee for the prevention of coercion, in my understanding. But you are entitled to hold your own opinion, and you should also expand it by reading reference materials. How this provision is presented, implemented in practice. Any question on interrogation? Any question regarding interrogation and also Article 35? That is, in my opinion, in my understanding, why I said it is for the purpose of preventing coercion. Why I said is that because a statement made before interrogation, statement confession made during interrogation can be rebutted in court. One means of rebutting is proving to the court that, presenting to the court, to the trial court, the statement made during the court in accordance with Article 35. So if there is any discrepancy, obviously the court will reject the statement made before the police. Because the statement in the law of evidence, the statement made before a court is more credible than the statement made before police. So obviously the statement made before a court will be admissible. You cannot say, for example, I was coerced before a court. Okay? If you prove to the court that there is contradictory, then at the trial stage, the trial court may easily ignore the statement even during police interrogation. So, በኢንተሮጌሽን ጊዜ አንድ ሰው ተገዶ ኮርስ ኢንክሪሚናቶሪ ስቴትመንት ኮንፌስ ቢያደርግ በ35 መሰረት ሲወሰድ የተለየ ስቴትመንት ኮንፌስ እንደተደረገ ኮርስ እንደተደረገ ለፍርድ ቤቱ ሲናገር ፍርድ ቤቱ ይመዘግባል። ዜን አት ዘ ትራያል ስቴጅ ቀርቦ አይ ተገድጄ ነው ተደብድቤ ነው የፖሊስ ማስረጃ ሲቀርበት ተደብድቤ ነው ማስረጃ ምንድነው ሲባል በ35 መሰረት የሰጠውት ቃል አለ እሱ ይታይልኝ ይላል። At that moment, the court should reject. The court should reject. ለዚህ ነው የ35 ጥቅም in my understanding it is this. But as I told you, there is divergence in understanding Article 35. In practice also, it is not used as a means of preventing coercion and confession and challenge ለማድረግ in practice ብዙም አይጠቀሙበትም. Please. You see, from the very beginning, it says the court will record statement and confession. It says the purpose of the court is recording statement or confession. Okay.
Police station.
Sorry.
Police station.
He will be given option to make a statement. Of course, some question may be asked by the court. Voluntary መሆኑን as a judge ለምሳሌ ያ ሰውዬ በ35 መሰረት ሲቀርብል ፍርድ ቤት በ35 መሰረት ሲቀርብል እንደ ዳኛ ሪከርድ ለማድረግ ዝግጁ ትሆናለህ። ስለዚህ ለተጠርጣሪው ሰውዬ ስለ ወንጀሉ ተናግረህ በዚህ ወንጀል ተጠርጥረህ መጥተሃል ተቀርበሃል። ስለዚህ መናገር የምትፈልገው ነገር አለ ወይ? ቮለንተሪ መሆኑን ቼክ አድርገህ ቮለንተሪ መሆኑን ቼክ ታደርጋለህ። ማለት የሚናገረው ነገር በፍቃደኝነት መሆኑን ቼክ ታደርጋለህ እና አምነህና ወደህ ነው ፈቅደህ ነው ለመናገር የመጣኸው ትላለህ። አዎ ተከብሮ ፍርድ ቤት ካለ ከዛ መቀጥ መናገር ትችላለህ ይባላል። ያ የሚናገረው ነገር ወንጀሉን አልፈጸምኩም ተገድጄ በፖሊስ ተደብድቤ ፖሊስ ላይ ጥያቄ ስጠይቅ ተደብድቤ አምኛለሁ ምናምን ሊል ይችላል። ታስቶ ቢርከድ ወይም ደግሞ ፖሊስ ላይ ያመነውን ወንጀሉን አምኜ ለማረጋገጥ ፍርድ ቤት ወንጀሉን ስለማመኔ ለመናገር ነው የመጣሁት ይላል። ዝርዝር ይጠይቀዋል ፍርድ ቤቱ የጠየቀው ያን ሁሉ ፍርድ ቤቱ ሪከርድ ያደርጋል። የጻፈውን ነገር ይነበብለታል። then he has to be signed. ስለዚህ ዞሮ ስለ ወንጀሉ ነው የሚጠይቀው። እሱ በደንብ እንዲናገር ሪከርድ ምክንያቱም ኮንፌሽን ሊሆን ይችላል የሚናገረው ወይም የተለየ ነገር ሊናገር ይችላል። በፍርድ ቤቱ አስፈላጊ ጥያቄዎች ይጠይቃል። then the purpose is to check whether he is willing to make confession or another statement. cross examination ምናምን የለውም። any other question?
ተመሪናሮቹና ኢንተሮጌተሮቹ በኋላ አንዳይን ናቸው እነሱ አንዳይን ቦሪ ከሆነ ወን ተብሎ የሚሰራ ነገር እሱን ኮርስን ለማድረግ ከፈለጉ መረጃውን ሊያጠፉት ይችላል። ወደ ኤግዛም ያደርጉት ነው።
in practice ብዙ ነገር ይሰራል exactly. But the purpose of the law is at least to give you to check or to prevent coercion. አሁን በህጉ ያስቀመጠው ነገር እንዲህ ሊያደርጉ ይችላሉ እንዴ? አዎ እውነት ነው። በጣም በፕራክቲስም እየተደረገ ነው። በህጉ ያስቀመጠውን ነገር ለማምለጥ ይሄን መከላከል ፕራክቲስ ብዙ ነገር ሊያደርጉ ይችላሉ። ለምሳሌ ምንም ስካር እንዳይኖርባቸው አድርገው ሽፍት ሊያደርጉ ይችላሉ። እንደውም የፖሊስ የሆነች የምትገርም መሳሪያ አለቻቸው አይደል? ወይ ጠባሳ ይወጣል ወይ አይደማ የሚልካችሁ ግን ያው የተመታ ሰው ነው የሚያልቀው። አንዴ በፌደራል ስለተመታ ነው። Continue to the next provisions, very important provisions on search and seizure. The provision. Under this section, what we are going to do is, so this is the other very important means of gathering of evidence by the police. Okay, the other very important means of gathering of the police. I don't know why they are bringing it here. So, evidence may be gathered by the police through searching the person, searching the arrested person, okay, and searching, undertaking physical examination, including blood examination, physical examination including blood examination sometimes, and searching of premises, meaning searching house or any residence you have. So by searching, the police gathers evidence. This is a very important means of gathering of evidence by the police. The law has provided precautions for this. It needs precaution. So every power given to the executive branch is, followed by a precaution. All right. So because this searching power of the police may be abused, so it should have such checking mechanisms. Okay. So first we will see searching of the physical person, the arrested person, searching of the physical person. Then we will see searching of premise, then physical examination, which is a bit different from searching of person. Okay, let you please read Article 32. Article 32, search and seizure. So, any investigating police officer or member of the police may make searches or seizures in accordance with the provisions which follow. And so Article 1, no arrested person shall be searched except where it is reasonably suspected that he has about his person any articles which may be material as evidence in respect of the offence with which he is accused or is suspected to have committed. A search shall be made by a person of the same sex as the arrested person. Okay? So there is the first important element is there has to be reasonable suspicion. The police should reasonably suspect. What should he suspect? He should reasonably suspect that he has about his person any article which may be material as evidence. Okay, respect to the offence with which he is arrested or is suspected to have committed. So the person, like for example, maybe that person is suspected of stealing mobile. So if the police officer suspects that he has about his person, like maybe in his pocket or somewhere, okay, about his person, he has hidden the material in respect of which he is suspected to have committed. Mobile የሚመስል ነገር ካየ ሞባይል የሚመስል ነገር የያዘ ከመሰለው ቶሎ ብሎ መበርበር ይችላል። ምክንያቱም በሞባይል መስረቅ አለ የተጠረጠረው። ድረግ ትራፊኪንግ ከሆነ ሐሺሽ ለምሳሌ ሐሺሽ የያዘ ከመሰለው ቶሎ ብሎ እንደዚህ ሲያደርግ ካየው ሲደብቅ ካየው if he has reasonable suspicion መበርበር ይችላል። እሱ ሬስቶራንት ያስፈልጋል። ሰሞኑን ስም ያስፈልጋል። ዶክተር ዲዛ arrested person አይደለ? ያዘ ሰው ከተያዘ በኋላ ወደ ቦታ ሊደብቅ ይችላል ቶሎ ብሎ ይሰይ። ስለዚህ እንደዚህ ከሆነ ቶሎ መበርበር ይችላል። but there has to be reasonable suspicion and connection መኖር አለበት ነው ሌላው ነገር። ኮኔክሽን መኖር አለበት። ለምሳሌ በሞባይል ስልክ ተጠርጥሮ የተያዘ ሰው ዱቄት መሳይ ነገር እንደው ሐሺሽ ይዟል እንዴ ብሎ እግረ መንገዱን አሽሽ መበርበር አይችልም ማለት ነው። ይሄ ወይም ደግሞ እንዴ ሰውዬው ቦምብ ነው እንደያዘው ብሎ መበርበር አይችልም። የተገናኘ ነገር መሆን አለበት። It has to be respect to the offense with which he is suspected to have committed ነው። The laws provide such strict guarantee. ለምሳሌ ጋራንቲ የተቀመጠው በጣም important, it's very important because otherwise it will be easily abused. በቃ ማያስፈልገው ነገር ሁሉ ላይ ብዙ ጊዜ abuse ይደረጋል. So it is a guarantee. And sub-article 2 no so this is about sub-article 1 እና በተመሳሳይ ጾታ መሆን አለበት. That's a very important guarantee. ከዚህ የምትረዱት እንግዲህ ይሄን ልብስ ማውለቅ ሁሉ ይኖር ይችላል ማለት ነው። some people በጣም የሚገርም አይነት ወንጀል የሚሰሩ ሰዎች እኮ አሉ። በጣም የሚገርም አይነት የማይጠረጠር ቦታው እንደሚያስቀምጡዋል። so it's the nature, it's our nature. ተፈጥሮ ባሪየር ስላለ ተመሳሳይ ጾታ መሆን አለበት። there has to be okay ለምን እንደሚያስደርገው ተበነ about premise ስለ premise ነው የሚያወራው። የመኖሪያ ቤት ሊሆን ይችላል። yes please እዚህ ጋር ማጥረቁኝ ማለት ኮንትሮቨርሺያል actually ከተያዘው ጋር አሁን ለምሳሌ አንድ ሰው ከወንጀሉ ጋር ማይገናኝ ሆኖ ከተጠረጠረበት ጋር ማይገናኝ ሆኖ ሌላ ዴንጀረስ የሆነ ነገር መያዙ ከተረጋገጠ ራሱ ሌላ ወንጀል ሆነ ማለት ነው አይደል? ለምሳሌ ድረግ ኪሴ ውስጥ ቢገኝ እኔ ሞባይል ሰርቃል ተብዬ ታስሰውዬ ድረግ ኪሴ ውስጥ ቢገኝ ድረግ ትራፊኪንግ is an independent offense አይደል? ራሱ የቻለው ወንጀል so the police has to follow procedures of arresting me for drug trafficking. So it becomes ምን አይነት ወንጀል ሆነ ማለት ነው? አሁን ልክ እዚህ ከፍጅ ከተያዝኩኝ አሽሽ ከተያዝኩኝ ምን ሆነ ማለት ነው? ምን አይነት ወንጀል ሆነ ማለት ነው? ፍላግራንት ሆነ ማለት ነው አይደል? ፍላግራንት ግን ፍላግራንት የሆነው ከ18 እስከ 20 ያለውን ፕሮቪዥኖች ውስጥ ተነቧቸው ያንን ክራይቴሪያ ማሟላት አለበት። ላይክ አሁን እየበረበረኝ ነው፣ ሌላ መብቴን እየጣሰ ነው የሰውዬ እየበረበረኝ ነው፣ ለዛ ሲበረበር ነው ይሄን ነገር ያገኘው። ይሄ ነገር ፍላግራንት ሊባል ይችላል። ኦኬ ፍላግራንሲ ውስጥ የሚወርድ ከሆነ ስፋይን አለበለዚያ ግን ዞሮ if you see the commission of an offense ለማንኛውም ሰው ፖሊስ ፕሮሲጀሩ መከተል አለበት። he has to follow the procedures and make an arrest irrespective of that offense. ጥንቃቄ አድርጎ ህጉ ከልክሎኛል እንዴ እኔ እኮ ሞባይል የሰረቀ ሰው ነው እንጂ ማሳደው አሽሽ ያዘው ሰው ምን አገባኝ ማለት የለበትም። police should be precaution, he has to take precaution and he has to follow to arrest me for that offense. ማስፈለጊው ጥንቃቄ አድርጎ እንዳላመልጥ አድርጎ ፕሮሲጀሩን ተከትሎ ለዛ ወንጀል እኔ ቁጥጥር ስር አውሎ ለዛ ለሌላ ወንጀል እንደገና ምርመራ ማድረግ አለበት። ግን ይሄንን ወንጀል አስመልክቶ ግን ሐሺሽን እንደማስረጃ ማቅረብ አይችልም። ሐሺሽንም ፕሮሲጀሩን ሳይከተል አገኘው ብሎ ዘው ብሎ ጋታችን መያዝ አይችልም። that is the intention of the law. Okay, now let's consider about premise because we have to finish about these issues today. ዛሬ ግን መጨረስ ስላለብን ነው። ስለ premise ደግሞ premise searching of premise sub-article 2 no premise may be searched unless the police officer or member of the police is in possession of search warrant in the form prescribed in the third stage of this code. Mind you, in the first case, in the first scenario under sub-article 1, search warrant is not important. Search warrant is valid. Search warrant is very important insofar as searching of premise is concerned. Searching of premise is concerned, search warrant is very important. በነገራችን ላይ ኦኬ ሜቢ እቺኛውን ስንጨርሳት አነሳላችኋለሁ። አንድ ሰው መኪና ውስጥ ቢገኝስ? መኪና ውስጥ ብዙ ጊዜ መኪና ብዙ ሸፍቶች ይሰራሉ አይደል? አንድ ሰው ምንም ሳያስበው የመኪና ኮቨን ውስጥ ኋላ ያስቀምጥበታል። ብዙ አይነት ወንጀሎች ይሰራሉ። and you might have also heard in these days like ወሌላ ሀገር የሚሄዱ ሰዎች እቃቸው ውስጥ ሐሺሽ የተቀመጠባቸው እዛ ሲደርሱ ተገኘባቸው ተብሎ ይያዛል። and also ዝም ብሎ በየመንገድ ላይ ትበረበራላችሁ አይደል? እሱንስ እንዴት አይደላችሁ? how do you see this? okay መንገድ ላይ ለምሳሌ አሁን እዚህ ጅማ ውስጥ ዝም ብሎ ድንገት መንገድ ላይ ቆምና ተበረበራል። is it in accordance with the criminal procedure code? Or there has to be some legal background, some legal justification for that. Okay? So these are the issues that you may raise. Then, basic whenever premise is searched, there has to be search warrant. But there are exceptions under subarticle A and B. Under subarticle A and B. Subarticle A says, the first exception, an offense is followed, an offender is followed in hot pursuit. Hot pursuit. Hot pursuit. And enters premise or disposes of articles, the subject matter of an offense in premise. Dispose or borrow. Okay, you want to give use or borrow. Or he enters, okay? And enters premise or disposes of articles, the subject matter of an offense in premise. So he is in what pursuit? He was apprehended by, okay? The suspect was apprehended by the police. So what he do is, and then whatever, የሆነ ግቢ ውስጥ ወርውራ ሊሮጥ ይችላል። በዚህ ጊዜ ፖሊስ ገና ቆይ እዚህ ግቢ ውስጥ ለመግባት ሰርች ዋራንት እና ማለት የለበትም። ቪዛ ሰርች ዋራንት እዛ ውስጥ መግባት ይችላል። ወይም ደግሞ እየሮጠ የሆነ ግቢ ዘሎ ቢገባ ኦኬ፣ ተጠርጣሪ የሆነ ግቢ ዘሎ ቢገባ ይሄን ፖሊስ አብሮ ዘሎ መግባት ይችላል። እንዴ ተጠርጣሪ ብቻ ህግ ጥሶ ፖሊሱን ግን ህግ አክብር ማለት doesn't make sense አይደል? ሁለተኛ ነገር ደግሞ ይሄ ፖሊስ for the purpose of serving justice ሰርቭ ለማድረግ ይሆናል ስለሆነ ኦሬዲ ተጠርጣሪውን ጥሶ ሌባውን ጥሶ ገብቷል እንኳን ፖሊስ። ስለዚህ this is an exception. ኦኬ፣ ስለዚህ ነገርየውን የሰው ግቢ ውስጥ ከወረወረና ከሄደ ወይም ራሱ እዛ ግቢ ውስጥ ከገባ ፖሊስ ያረ ሰርች ዋራንት you can enter into premise ነው። ፕሊዝ እሺ፣
ያሳደው ሰው ፖሊስ በሉስ
ይቻላል እንዴ? አይቲ ስቶኪንግ መንዳቶሪ ነው ያለው። በምን ወቅት ነው አንድ ሰው ለምሳሌ ፕራይቬት ፐርሰንስ አባረር መያዝ እንችላለን? is it possible to run after a police and a suspect and arrest that person? ይቻላል? የምር ሶሪ ዝም ብሎ ያለን አባሮ ይዘላል ሞባይሉን ለማስመለስ። በዛን ጊዜ ሰው ግቢ ቢገባ ያ ሰውዬ መግባት ይችላል ወይ? What do you think? We are considering about the police. Whenever police is arresting that person, whenever police is apprehending that person, if that person enters into the premise of another person, or if he disposes any property in that premise, police can enter into that premise without search warrant. Police doesn't need, in that case, search warrant. And subarticle B. Information is given to an investigating police officer or members of the police that there is reasonable cause for suspecting that articles which may be material as evidence in respect of an offense, in respect of which an accusation or complaint has been made under Article 14 or of this code, and the offense is punishable with more than 3 years imprisonment, are concealed or lodged in any place, and has good grounds for believing that by reason of the delay in obtaining such warrant, such articles are likely to be removed. But I'm ready to say something. Very long sentence. Okay. Now the point is, the property in respect of which the person is suspected, okay, is lodged, okay, in any place. It is lodged. And there is also another precondition. It has to be punishable with more than 3 years imprisonment. So these preconditions should be fulfilled. So let me say, in a certain place, a prohibited material like drugs or whatever, it is a prohibited. And in respect of the person is suspected of drug trafficking, for example, the person is suspected of drug trafficking, and the police got an information that these drugs are lodged in a certain place. lodged in a certain place. And until a search warrant is issued, these things may be easily removed. So in such cases, it is possible to search without a warrant. ስለዚህ ወንጀሉ ጋር የተያያዘ ነገር የሆነ ቦታ እንደተከማቸ ፖሊስ ካወቀ እና ሰርች ዋራንት እስኪያመጣ ድረስ ግን ሊያሸሹት ስለሚችሉ ያኔ በፍጥነት እና ደግሞ it has to entail more than 3 years imprisonment ይላል ነገርየው ተካሻ ነገር መሆን የለበትም it has to be a bit serious thing a bit serious matter ከሆነ search warrant ሳይኖር it is possible to enter into premises without a search warrant. Well, the purpose is to, not to give opportunity for the suspected person to conceal or to destroy the evidence. Evidence እንዳይጠፋ ቶሎ አማራጭ ለማስቀመጥ ነው. That's an option for the police officer. Okay, this is all about searching of premise and searching of person. So you can raise a number of questions. I know you would have a number of questions. ብዙ ጥያቄዎች ይኖራሉ like searching ጋር ተያይዞ በተለይ በጣም ብዙ ነገሮች አሉ። አሁን ለምሳሌ በቅርቡ ኤርፖርት መሰራ ሰራተኛ እቃ ውስጥ ከሽሽ ተደርጎበት she was arrested አይደል ቱርክ ውስጥ ነው አይደል ከዛ በፊትም ደግሞ እንደዚህ ቻይና by the way እቃቹን በጣም በጥንቃቄ መከታተል ተጠበቅባቸዋል you have to be very careful ሻንጣ ውስጥ እኔ ያላየሁትም አይሰራም ሻንጣቸው ውስጥ በትራንስፖርት እናንተ ተማሪ ናቸው በፕሌን አትሄዱ መኪና ውስጥ አንዳንድ ጊዜ ሻንጣችሁን ከዛ በኋላ ያ ሰውዬ የሆነ ነገር አስቀምጦ ፊት ለፊታችሁ ለምሳሌ ፖሊስ ድንገት ሰርቺንግ ኢሚዲየትሊ የሆነ ቦታ አስቆሞ ፖሊስ የበረበረ አጠገባችሁ ሻንጣ አግኝቶ ውስጡ ይሌጋል ነገር ቢኖር የኔ አይደለም የምትሉ ራሱ ይቻላል እንዴ አጠገባችሁ ነው ከሆነ የሆነ ሰው አስቀምጦ እሱ ሄዶ መጨረሻ ምናልባት ሊቀመጥ ይችላል የኮንትሮባንድ ነገር ሊሆን ይችላል whatever አስቀምጦ መጨረሻ ይቀመጣል ፕራክቲካሊ ስላጋጠመኝ it takes time for you to prove your innocence ንጽህናቸውን ለማረጋገጥ በጣም it takes time. Okay, so this is about searching of premise and searching of physical person. The other very important is searching of physical examination. No, let's also see the other very important controversial matter regarding searching. Article 33 and 9 we will wind up today's class. Article 33. Okay, very quickly Article 33 number 2. Issue of search warrant. Article 1. A search warrant may be issued by any court. It may be issued by any court. No search warrant shall be issued unless the court is satisfied that the purpose of justice or of any inquiry, trial or other proceedings under this code will be served by the issue of search warrant. So this is a very important provision. The court should check, it means the court should check whether there is justifiable ground, whether search warrant is important. Otherwise, police may abuse it. The court shouldn't simply issue whenever it is asked, it means. Unless the court is satisfied that the purpose of justice or of any inquiry, trial or other proceedings under this code shall be served by the issue of search warrant. That is, the court should ask the police why search warrant is needed. Okay? Then every search warrant issued shall specify the property to be searched for and says no investigating police officer or member of the police may seize any property other than that specified in the search warrant. This is again the other very controversial provision. Like the question that your classmate asked. Whenever search warrant is issued, then the search warrant should specify the property that is going to be seized, that is going to be searched and seized. So the police may apply to the court saying that I have reasonable doubt, I have reasonable suspicion that an illegal drug is stored in a certain premise. You should present his evidence, for example, to justify the court. He should convince the court. So in such cases, the court will issue search warrant. That warrant should specify the property to be searched. Okay? So if it is drug, then it has to be, drug should be mentioned in the search warrant. So using the search warrant, police should only search and seize drugs. It should only search and seize those which is listed in the search warrant. Okay? Otherwise, police cannot say. Because it says clearly, every search warrant issued shall specify the property to be searched for and says, and no investigating police officer or member of the police may seize any property other than that specified in the search warrant. So it is clear. Even though an illegal material is found, police cannot seize it. Means police cannot seize. On this way, police may find other illegal materials while searching for drugs and other materials, maybe weapons, for example. Whatever, police cannot do that, cannot seize. And Article 3, on seizing the property, such investigating police officer or member of the police shall make a list of property seized and, where possible, shall have the list checked and signed by an independent person. Look, this is a very important guarantee. By seizing, the property seized will be recorded, and an independent person should come and verify it. ስለዚህ ለምሳሌ እንዳልኳችሁ ይሄ ተረጋጋሚ ዛሬ አሽሽ ላይ ነው እንግዲህ ያዘዘኝ these drugs የተያዙ ድረጎች ካሉ ይመዘገባል። ፖሊስ መዘገብና ኢንዲፔንደንት ፐርሰን መጥቶ ቬሪፋይ ማድረግ አለበት። የተጻፈውና በፖሊስ የተያዘው አንድ አይነት ነው ቬሪፋይ ማድረግ አለበት። that independent person should verify. Okay? Please, yes. Police should find በምድሩ ሰው ነው አሳምሽኑ ሰው አይጠፋም። እኔ መንገደኛ ሊሆን ይችላል። ኢንዲፔንደንት ሰው ሲባል እኔ ተባባሪ እኔ ሎ አባይዲንግ ሲቲዝን ሊሆን ይችላል። መንገደኛ ሊሆን ይችላል። ማንም ሰው ኢንዲፔንደንት የፖሊስ ኦፊሰር ደግሞ መሆን የለበትም። that person shouldn't be from the law enforcement authority. He has to be civilian, not related to the enforcement process. So you should find that person and verify it. Any property seized which is required for the trial shall be preserved in a safe place until handed over to the court as an exhibit. Any property not so required may be returned to the person from whom it was taken, and a receipt shall be taken. This is the procedural provision. ንብረቶቻቸው አላግባብ ተወስዶባቸው ሊሆን ይችላል። ከንብረቱ ጋር ከወንጀል ጋር ተያይዞ በኋላ ላይ ማያስፈልገው ነው ሲገኝ ሪሲት ሊሰጣቸው ይገባል። ሪሲት ተሰጣቸው ሊመለስላቸው ይገባል። ይሄ procedural matter to protect the right to property of a person. And in effecting Article 4, in effecting a search, the investigating police officer or member of the police may use such force as is necessary and may, where access to premise is denied, use reasonable force to effect entry. So the necessary measure was available. Police may be allowed to use force. አንዳንድ ሰው ሰርች ዋራንት ራሱ ያሳየው ቤት ያዳም ብሎ ቢከራከራል። ቤት በፍጹም አልገባም። እንደዚህ አይነት ሰው ሲያጋጥመው ፖሊስ reasonable force መጠቀም አለበት። Unless otherwise expressly ordered by the court, searches shall be carried out only between the hours of 6 a.m. and 6 p.m. 6 a.m. ከጠዋቱ ስንት ሰዓት ነው? and 6 p.m. ስንት ነው? 12 ሰዓት። በቃ በዚህ unless ይላል ኤክሰፕሽን አለ። ፖሊስ ሞኝ አይደለም ማለት ሌባ ሞኝ አይደለም። clearly knows this. ብዙ ጊዜ they are very careful. abuse ይደረግ ይችላል ይሄ ነገር። ስለዚህ abuse እንዳይደረግ there is an exception unless otherwise expressly ordered by the court ይላል። ስለዚህ ፖሊስ prudent ፖሊስ ይሄን ነገር ለፍርድ ቤቱ አስረድቶ አይ ለምሳሌ ከምሽቱ 4 ሰዓት ሊሆን ይችላል። ከምሽቱ 4 ሰዓት ላይ ሊያወጡ ይችላሉ። 5 ሰዓት በሌሊት ሊያወጡ ይችላሉ። ብዙ ጊዜ እንደዛ ነው። ለፍርድ ቤቱ አስረድቶ መበርበር ይችላል። unless the court authorizes አይቻልም። በዚህ ጊዜ ውስጥ ነው የሚቻለው። ከወራ 7 ሰዓት ከምሽቱ 2 ሰዓት ሬስቶራንት ላይ እንደዚህ ያለ ነው። ሬስቶራንት ላይ ከምሽቱ 4 ሰዓት ላይ መጥቶ እናንተ ሊይዛችሁ ይችላል። is there any precaution? See, let's stop here. Next time we will continue from this. If you have any question and including your questions, entertain our class.